When does a legal dispute stop being about the defendant and start becoming about the lawyers themselves? That's the question many legal analysts began asking after reports emerged that multiple senior attorneys representing former President Donald Trump withdrew from active representation within a very short period of time. At first glance, attorney turnover doesn't seem unusual. High-profile legal teams change all the time. Large cases often involve dozens of lawyers rotating in undoubt as different phases of litigation unfold. To the average observer, another resignation may look like little more than personnel news. But simultaneous departures by several senior attorneys during ongoing litigation are different. They raise questions that extend far beyond politics. They force observers to ask whether the dispute is driven by legal strategy, attorney-client relationships, professional ethics, or some combination of all three. And in complex litigation, those distinctions matter. Because unlike political advisors or campaign consultants, attorneys don't simply advocate for a client. They are also officers of the court, bound by professional rules that define what arguments they may present, what evidence they may use, and where ethical boundaries cannot be crossed. That dual responsibility creates an unusual dynamic. A lawyer's job is to defend the client as aggressively as the law allows, but not beyond that line. When disagreements emerge over where that line exists, representation itself can become difficult to maintain. According to publicly available court records and media reporting, several experienced attorneys sought permission to withdraw from representing Trump, citing disagreements related to legal strategy and professional obligations. While the specific details remain subject to legal proceedings and competing interpretations, the withdrawals immediately fueled debate over what was happening behind closed doors. Supporters of Trump argued that experienced defense lawyers were facing extraordinary political pressure in one of the most closely watched legal battles in modern American history. Critics suggested the resignations reflected deeper disagreements about litigation strategy and ethical responsibilities. Both interpretations continue to circulate. At the time of writing, many of the underlying claims remained contested, and some allegations have not been independently verified in court. That distinction is important because legal disputes often generate competing narratives long before judges issue definitive rulings, regardless of which interpretation ultimately proves more accurate. The resignations highlight a broader issue that extends well beyond one defendant. They illustrate how extraordinarily difficult it has become to represent political figures whose legal cases unfold under constant public scrutiny. Every filing becomes national news. Every courtroom argument is dissected online within minutes. Every strategic decision is evaluated simultaneously by judges, opposing counsel, political commentators, and millions of voters. Very few legal teams operate under that level of pressure. Understanding why this matters also requires understanding the scale of Trump's legal challenges. Rather than defending a single lawsuit, his attorneys have been navigating multiple civil and criminal proceedings across different jurisdictions, each with separate judges, prosecutors, procedural rules, and deadlines. Managing that workload demands not only legal expertise but also exceptional coordination. Losing experienced senior counsel during active litigation can therefore create operational challenges regardless of the political context. New attorneys must familiarize themselves with thousands of pages of filings, extensive evidence, prior court rulings, and evolving litigation strategies before they can effectively represent a client. That process takes time, and in high-profile federal litigation, time is often the one resource neither side possesses in abundance. So before asking whether these resignations help or hurt Trump's legal position, there's a more important question to answer. What actually causes experienced trial lawyers to walk away from a major case while it is still unfolding? To answer that, we need to examine the professional rules governing attorney-client relationships and why strategy and courtroom risk don't always point in the same direction. To understand why experienced defense attorneys sometimes leave high-profile cases, it's important to understand how legal strategy is actually developed. Contrary to popular perception, a criminal defense attorney doesn't simply carry out every instruction a client gives. The client decides the overall objective, whether to fight the charges, negotiate a settlement, or proceed to trial. But the attorney controls the legal strategy used to pursue that objective. That distinction is fundamental to the American legal system. Attorneys are obligated to advocate aggressively for their clients, but they must also comply with court rules, professional ethics, and evidentiary standards. If they knowingly present arguments they believe lack a reasonable legal basis, they risk far more than losing a motion. They may expose themselves to court sanctions, disciplinary action, or even damage to their professional licenses. In ordinary litigation, disagreements over strategy happen every day. Most remain private. Lawyers advise, Clients disagree. Both sides compromise. The case moves forward. High-profile political litigation is different because every strategic disagreement carries consequences beyond the courtroom. Legal arguments become political talking points. Court filings become media headlines. Every procedural decision is immediately interpreted through a partisan lens. That environment increases pressure on both attorneys and clients. According to publicly available reporting, one of the central areas of disagreement involved how aggressively Trump's legal team should challenge certain aspects of the ongoing proceedings. Supporters of the former president argue that unconventional cases require unconventional legal strategies and that vigorous constitutional challenges are entirely appropriate. Others contend that experienced defense attorneys have an obligation to avoid arguments they believe are unlikely to succeed or could undermine their broader defense. Those are not necessarily contradictory positions. They simply reflect different assessments of legal risk. Professional trial lawyers constantly evaluate three questions before filing any motion. First, does the argument have a credible legal foundation? Second, even if the motion is denied, does it strengthen the overall defense strategy? And third, could pursuing that argument create unintended consequences later in the case? In politically charged litigation, those calculations become significantly more complicated. A filing that energizes public supporters may have little value inside a courtroom. Likewise, a legally cautious approach may appear politically weak, even if it improves the client's long-term position before the judge. This tension often produces friction between attorneys focused on litigation and clients focused on public messaging. Another factor is the sheer complexity of managing multiple cases simultaneously. Trump's legal challenges span different courts, different judges, different procedural rules, and different timelines. Every filing in one jurisdiction can influence litigation elsewhere. As a result, senior attorneys must coordinate strategy across several independent legal teams while ensuring that arguments made in one courtroom do not inadvertently complicate another case. That level of coordination requires extraordinary discipline. Even minor disagreements can become magnified when deadlines overlap and legal resources are stretched. There's also a practical reality that receives far less public attention. Elite trial lawyers carefully manage professional reputation. Their credibility with judges, opposing counsel, and future clients represents one of their most valuable assets. Regardless of political affiliation, experienced litigators generally seek to avoid situations where professional judgment and client expectations become fundamentally incompatible. When that happens, withdrawal, although uncommon during active litigation, may become the least disruptive option available under applicable court procedures. None of this, by itself, proves wrongdoing by either side. Attorney withdrawals can occur for many reasons, including strategic disagreements, workload concerns, conflicts of interest, financial disputes, or evolving litigation priorities. At the time of rating, many details surrounding these departures remain the subject of competing public interpretations. What is clear, however, is that replacing experienced lead counsel in the middle of complex federal litigation is never a simple administrative task. It affects preparation, continuity, institutional knowledge, and ultimately the pace of the proceedings. And that raises the next question. If senior attorneys step aside during ongoing litigation, what does that mean for the defense itself, and could it alter the trajectory of the cases that still lie ahead? If the publicly reported timeline is accurate, the story now moves beyond individual resignations and into something far more significant. The real question is no longer why attorneys may have stepped away. The real question is what happens to a major federal defense when experienced counsel leaves in the middle of active litigation. Those are two very different issues. One is political, the other is procedural. And in American courts, procedure often matters far more than politics. According to publicly available court schedules, several of President Trump's criminal and civil cases continue to move forward under strict judicial deadlines. Judges generally do not pause litigation simply because a defendant changes attorneys. Deadlines remain. Discovery continues. Motions must still be filed. Witnesses must still appear. Whether the defense team consists of 3 attorneys or 30, the court expects the legal process to continue. That creates an immediate practical challenge. A new attorney doesn't simply walk into a courtroom and begin arguing. Complex federal litigation requires enormous preparation. Lawyers must review discovery materials that can span hundreds of thousands or even millions of pages. They need to understand months or years of prior filings, previous court rulings, witness statements, expert reports, and strategic decisions already made by prior counsel. Even an experienced federal defense lawyer cannot realistically absorb all of that overnight. Which raises an important strategic question. If experienced attorneys leave during active litigation, who replaces them? According to legal analysts, That may be more difficult than many people realize. High-profile political cases are already among the most demanding assignments in American law. They involve extraordinary media attention, extensive public scrutiny, and enormous professional pressure. Any attorney considering such representation must also evaluate conflicts of interest, available resources, scheduling constraints, and ethical obligations. None of those considerations are unique to this case. They apply in virtually every nationally significant criminal proceeding. If additional turnover were to occur, the defense could face several operational challenges. First comes continuity. Every legal team develops its own strategy over time. Arguments evolve. Witness preparation changes. Evidence is organized according to a specific theory of the case. Replacing senior attorneys means transferring not only documents, but also institutional knowledge. Some of that knowledge exists only through months of meetings, conversations, and courtroom experience. It cannot simply be downloaded into another lawyer. Second comes timing. Federal judges generally have broad discretion when considering requests for delays. New counsel demonstrates that additional preparation time is necessary to provide effective representation. Courts may grant limited continuances. However, that outcome is never automatic. Judges must also balance the public interest in resolving cases efficiently, the rights of other parties involved, and the overall administration of justice. Third comes credibility. According to former federal prosecutors who have commented publicly on similar situations, courts tend to distinguish between unavoidable legal developments and strategic delay. If a judge concludes that repeated attorney changes are preventing a case from moving forward, that may influence future scheduling decisions. Every situation depends on its own facts, but the possibility exists. There is another layer that receives far less attention. Modern litigation is increasingly about information management. Large legal teams coordinate investigators, forensic specialists, subject matter experts, electronic discovery vendors, and communications between multiple jurisdictions. Replacing senior leadership during ongoing proceedings affects far more than courtroom appearances. It changes how information flows inside the defense itself. Every transition creates opportunities for misunderstanding, duplicated work, or simple delays. Meanwhile, prosecutors continue preparing. Unlike political campaigns, litigation rarely pauses because headlines change. Government attorneys continue reviewing evidence, interviewing witnesses, preparing motions, and responding to court deadlines regardless of developments inside the opposing legal team. Time therefore becomes a strategic resource. If one side spends weeks reorganizing its defense structure while the other continues operating normally, that difference can become operationally significant. Of course, there is another perspective. Supporters of President Trump argue that attorney turnover does not necessarily indicate weakness. They point out that high-profile defendants often change counsel for strategic, financial, or personal reasons. Some also argue that lawyers representing politically controversial clients face extraordinary public pressure that ordinary criminal cases simply do not involve. Those arguments deserve consideration. Attorney withdrawals, by themselves, do not establish wrongdoing, nor do they determine the eventual outcome of any case. Experienced trial lawyers regularly remind observers that legal representation changes for many reasons, many of which remain confidential. That uncertainty is important. At the time of writing, much of the public discussion surrounding these reported departures remains based on media reporting, court filings, and outside legal analysis rather than fully litigated facts. What can be stated with confidence is much narrower. If senior attorneys leave during active litigation, replacing them quickly becomes both a logistical challenge and a strategic one. The longer that process takes, the greater the pressure on whichever legal team ultimately assumes responsibility. And that brings us to perhaps the biggest question moving forward. This story is no longer simply about personalities or politics. It has become a test of legal endurance. Can the defense maintain continuity under mounting procedural pressure? Or will repeated organizational changes gradually reshape the balance of the litigation itself? Those questions, not the headlines, are likely to determine what happens next. Stepping back from the headlines, this story ultimately raises a broader question than whether one legal team changed personnel. It asks how America's legal system functions when a defendant is also one of the country's most polarizing political figures. In an ordinary criminal case, attorney withdrawals rarely become national news. Judges address the issue. Replacement counsel appears, and litigation continues with relatively little public attention. High-profile political cases operate under very different conditions. Every motion becomes breaking news. Every scheduling order is analyzed for political meaning. Every attorney is viewed not only as a legal advocate, but also as a public figure whose decisions are interpreted through a partisan lens. That environment creates pressure like almost any other area of legal practice. According to legal ethics experts, representing controversial clients has always been an essential part of the American justice system. Lawyers are expected to defend clients regardless of public opinion because the integrity of the legal process depends on everyone receiving competent representation. At the same time, attorneys also owe independent duties to the courts. Those two responsibilities occasionally come into conflict. When they do, professional judgment, not political loyalty, is supposed to determine how lawyers proceed. That principle exists to protect the justice system itself. Another strategic implication concerns future representation. If publicly reported disagreements between attorneys and clients become increasingly visible, some experienced litigators may become more selective about accepting politically charged cases. That does not mean defendants will be unable to find representation. It may simply change the composition of future legal teams. Large institutional law firms often evaluate reputational risk differently from smaller firms or independent practitioners. Individual attorneys also make different career decisions based on workload, professional interests, financial considerations, and personal judgment. Those dynamics are not unique to this case, but they become far more visible when the client is a former president. There is also a procedural dimension that extends beyond any single defendant. Federal courts rely heavily on continuity. Complex litigation is built around long-term planning, stable attorney-client relationships, and predictable case management. Frequent changes in counsel can increase costs, delay preparation, and complicate scheduling for judges, prosecutors, witnesses, and co-defendants alike. Whether those effects ultimately influence trial outcomes depends on many variables, but the administrative burden is real. Perhaps the most important takeaway is that this story should not be viewed simply as a political contest. It is also a case study in institutional resilience. Can courts maintain consistent procedures while operating under extraordinary public scrutiny? Can attorneys fulfill their ethical obligations despite intense political pressure from every direction? Can legal disputes remain focused on evidence and procedure rather than public perception? Those questions will continue long after any single motion is decided. At the time of writing, many aspects of this situation remain unresolved. Future court filings, judicial rulings, and any additional changes in legal representation will likely provide a clearer picture of what actually occurred behind the scenes. Until then, much of the public debate remains exactly that, a debate. The documented procedural developments are real. The motivations behind them are still being argued, and that distinction is worth remembering. In today's media environment, the loudest narrative often arrives before the strongest evidence. For analysts, lawyers, and informed observers, separating those two has become one of the most important skills in understanding modern American politics. This story is still developing. Whether it ultimately becomes a footnote in a long series of legal battles or a turning point in one of the most closely watched cases in recent history will depend not on headlines, but on what happens inside the courtroom in the months ahead. As always, we'll continue following the documents, the court proceedings, and the publicly available evidence because in cases like this, the legal record usually tells a more reliable story than the political conversation surrounding it.